We thank you so much for watching our channels Law School Made Easy at Law School Made Easy 256. We want to go to equity and trust. That's the question we want to look at, and we want to look at the maxims, of equity. There are several maxims of equity. We are going to pick a few, like 5, 6, and we explain them. We try to make an understanding of those maxims. We did a video about the case of Earl of Oxford, and in that video we explained the emergence of equity, how we arrived at equity, and we all know that the common law at the time was outdated, and it was being harsh. And because the common law was being harsh, equity came to remedy. Equity came to find a solution for the common law. I'll give an example. Those of you who did contract, if you remember, in contract law, there is a case of Carter versus Powell. That is a case under performance. Remember, the general rule in performance is that performance must be strict, precise, and exact. Okay, so in the case of Carter versus Powell, he was told to take a ship from Jamaica, Kingston to Liverpool. So he died on the way. His wife brought an action in court demanding that he should be paid for the work he had done. Court held that at common law, performance was supposed to be precise and exact. The event that he died before completing, he would not get any remedy. But of course, later, because of common law, things like quantum merit came through. You know, when we discuss the quantum merit, we mean that somebody should be paid for what he has done. Okay, it's what they call quantum merit. You are paid for only what you have done. Things like a specific performance came up. Things like the divisible contracts. Okay, they pay you per the lot you do. So that is what we mean by equity. Equity came to remedy the common law, which common law had gotten outdated at the time. So equity is here to help you appreciate where there is injustice. Equity provides a remedy. Okay, so equity in simple terms is a set of legal principles that supplement the common law. A set of legal principles that supplements the common law. Okay, now, when supplementing the common law, its sole aim is to bring fairness and justice. To bring fairness and justice. And to bring this fairness and justice, we have different maxims of equity, which you must follow. There are many, but let us start with this one. Equity follows the law. Equity follows the law. We are saying that equity does not override the law. It only follows the law. Equity respects the legal rights. So you can't come and say that because there is equity, you suppress the law. You cannot suppress the law because there is equity. Equity only and only supplements on the law. Look at that case of Reed Diplock, where it was held that the court held that equity follows legal principles unless it would be unfair to do so. Okay, we are saying that equity, in the case of Reed Diplock, court held that equity will always follow the legal principles, the law, unless it is unfair to do that. If following the law is going to bring injustices, then equity will not go there. will provide a remedy that does not bring injustices. Okay? So that is the maxim, equity follows the law. Let's look at the other one, that he who seeks equity must do equity. Another maxim, he who seeks equity must do equity. So we are saying, in other words, that a person asking for equitable relief must be ready to act fairly and fulfill their own equitable obligation. That if you want to seek equity, you must do equity. I don't know which example we can give. Let's take an example. When they say he who seeks equity must do equity, it means that, for example, if you were a tenant and you are seeking, they are going to evict you, okay? You are seeking for a remedy saying the landlord is sending me away, okay? If you want to get that equity, you first pay the outstanding rent. That way, you have done equity. You have not paid the money. They are demanding you 10 months, but you are running to seek for equity. So if you want to do equity, to get equity, you also do equity. That is the maxim. He who seeks equity must do equity. Let's take a case there. There's a case of Chapel versus Times Newspaper Limited. Chapel versus Times Newspaper Limited. It was said that the court refused an injunction to workers who had not complied with fair conduct. That this was a newspaper. So the court refused an injunction to workers who had not done equity, who had not followed a fair conduct. Okay? So, in other words, in the case of Chapel versus Times Newspaper Limited, court is saying that we are not giving you an injunction because you have not acted in the right manner. So, in other words, we are saying that he who seeks equity must do equity. Okay? Let's go to another one. Another maxim. Let's do, he who comes into equity must come with clean hands. If you come to equity, this maxim says, if you are seeking for equity, you must come with clean hands. You say, I need to be helped on this. But when you don't have any dent, let's take an example. A party who has falsified documents cannot seek specific performance of a contract. You have false documents, and then you come and tell court, no, let them do this. They are in wrong, but already you have forged documents. Okay? In that way, you cannot get equity. If you come at equity, you must come with clean hands. Let's take an example. You go and you borrow money from somewhere, let's say money lender, who has no license. Now you come and say, I'm not paying him, he doesn't have license. Your hands are dirty. You already knew that he doesn't have a license. But you went ahead and picked the money. Now you don't want to pay. You're saying, I need equity. This man is operating without a license. There is even a case in Uganda, I'm forgetting the parties. Court has put it clear that if you want to seek for equity, you must come with clean hands. Okay? That's when you'll be able to seek equity. So there is a case there. Let's look at the case of Dering. Dering is D-E-R-I-N-G versus Earl of Winchless. Winchless is W-I-N-C-H-E-L-S-E. Winchelsea. Winchelsea. Okay, the case of Dering versus Earl of Winchelsea. court held that the plaintiff had participated in fraud and therefore he could not be given an equitable relief because he had participated in fraud. His hands were dirty. So he who comes to equity must come with clean hands. Let's go to another one, very important one. Equity, delay defeats equity. Delay defeats equity. Delay defeats equity. Then you talk about equity aids the vigilant, not the indolent. This is also the same. But we are saying equity defeats, delay defeats equity. Here we are looking at the doctrine of laches. The time. For example, in civil proceedings, if somebody maybe stole your car and you keep quiet for 6 years, then you bring a case after 7 years, the doctrine of laches has caught you. Delay defeats equity. So if you want to seek equity, come within time. You can't be quiet for 10 years and then you remember, hey, someone stole my this, let me go and report. There, you are out of time. Delay defeats equity. So you must, if you want to seek equity, you must be on time. Let's take an example, those who remember the contract. Of course, when we say doctrine of laches, we mean delay. Okay? When you delay, the doctrine of laches you will get caught up with it. Those who remember the contract, we had a case of Leaf. We had a case of Leaf versus international galleries. If you remember very well, we had a case of Leaf versus international galleries. A buyer delayed for 5 years before claiming rescission of misrepresentation. The court denied this due to delay. That the buyer was given, I think it was a portrait art. For 5 years he was quiet. So he came after 5 years. The doctrine of laches caught with him. Delay. Laches means delay. You have delayed. You must come within time because we are saying delay defeats equity. For example, in land disputes, court normally denies injunctions because someone has slept on their right for over years and years. After 15 years, you are saying that I have come. That is why, if you remember under land law, the issue is, even when you are outside the country and you buy land, ensure that there is possession. There is someone on that land. Whatever, and make sure you know whatever is happening there. To avoid being caught by the doctrine of laches, you must know what is going on. So possession is key in land matters. Okay, let's go to another equity. I don't know, another maxim. I don't know how many we have given, but let's do equality is equity. Equality is equity. Now, when 2 or more parties have equal rights, equity treats them equally. I want to repeat this. When 2 or more parties have equal rights, equity treats them equally. One of the importance of this, when we are distributing property, let's say under succession, equality is equity. This will help when you are distributing property to ensure that everybody gets equal distribution of property. Okay? For example, when you buy land together, you bring, each one of you brings the same amount. When you want to separate, equity will ensure that everybody gets their share which they put in. It's what we mean. Equality is equity. Let's take a case of Lake versus Bailey's. Lake is L-A-K-E versus Bailey's. Bailey's is B-A-Y-L-I-S-E. In that case, parties contributed equally to purchase a property, and when they wanted to separate, quote, divided equally, to bring out the other principle that equality is equity. When you are doing equity, you must exercise equality. Okay? Let's look at the other maxim, which is equality. Equity looks at the intent rather than the form. Equity looks at the substance, not the form. Equity looks at the substance, not the form. I have my constitution here. I want to check Article 132E. Equity looks at the form. 132E. Yes. Oh, I'm not seeing the article now. Okay. Where equity will look at the substance over form. Okay. There is that case of UEB. Okay. You got any case? Forgetting the name. Where he was supposed to appeal. I'm forgetting the name. I remember. I'll put it in the bio. Where this man was supposed to appeal, there is a time given for appeal, but court took long to give him the appeal papers, and court held that we shall proceed with this case simply because we are looking at the substance, not form. Okay. Equity prioritizes the intention behind an act or document over its literal wording or technical form. It ensures that substance prevails over form. Okay? So we are saying under here that equity will look at the substance rather than the form. It will look at the gist. Okay, because in that case of the case I'm telling you, the Ghanaian case I'm just skipped my mind. They were telling this man that he had appealed out of time. If the court said no, the Supreme Court said no. This person, yes, he has appealed out of time. But it was the Court of Appeal that delayed. So that is form. Let's take the substance. What is he saying? And the case was heard. So I'll remember and I'll give you the case. Let's take an English case of Parkin versus Thorold. Parkin versus Thorold. Parkin is P-A-R-K-I-N versus Thorold is T-H-O-R-O-L-D. The court held that equity will consider the true intention of the parties, not merely the form of the transaction. You remember, those of you who have done contract and evidence, we have what we call the parole evidence rule, where a court seems to bring oral evidence to be admissible. Okay? So we are looking at the substance rather than the form. Court is looking at your intentions. What were the intentions? Okay? What did you want to achieve other than these petty things which come along with the transaction? And there is a whole article in the Constitution which I think is 130. I want us to read this together. Where quote strictly says that we shall look at form rather than the substance. Form rather than the substance. It is okay. Yes, 126, which says that substantive justice shall be administered without undue regard to technicalities. 126E, substantive justice shall be administered without undue regard to technicality. That is 126E. Okay, so that is the maxim. So let's look at where equities are equal. The first in time takes precedent. Where two equities are equal, the first in time takes precedent. This is very evident. Look at all those land cases. Okay, look at section 48 of the RTA, that the first in time will always take precedent. You can later section 48 of the RTA and 54 of the RTA. Now, where there are two equities, the first in time takes precedent. I will give an example. If we have two competing interests, let's say legal over equitable interest, they are both interests which are in land, but the first in time takes precedent. There can be two legal interests, legal versus legal, okay? But the first in time will take precedent. And under the RTA, it's clear, the first to register takes precedent. So with the one that comes first takes precedent. You read with the RTA. Let's look at the case of Rice versus Rice. These parties had two equitable mortgages. The first in time prevailed since both had equal equities. They both had two equitable mortgages, but court held that let the first in time takes precedent. So in law, what comes first will always take precedent. Where you have two equities, the first in time will always take precedent. And very many others. We have equity imputes an intention to fulfill an obligation. We have equity acts in personam. Equity acts in personam and in personam. We have equity looks at that as done, which ought to be done, and very many others. Those are the few we have been able to do. This has been Law School Made Easy at Law School Made Easy 256. Subscribe, share, like our videos. Until next time, thank you.